There are times when code enforcement can be oppressive and take an active role in violating your rights and freedoms. If they are exceeding their authority, which is true most of the time, they can be stopped with a federal lawsuit. And this is a tutorial on how to prepare and file such a lawsuit. There are a number of ways to stop them from violating your rights. I have given one or two examples here. Hello, I'm Jeff Smith, the author of New Horizons in Natural Cancer Therapies, which is available at naturalcancertherapies.net on the net. Please direct anyone you know to the website if they are suffering from cancer and looking for creative solutions without side effects. We also have a book on alternative remedies for diabetes. Now let's talk about how to sue code enforcement. In most cases, you will have to file a lawsuit against code enforcement to stop them from disrupting your life, or in some cases, bulldozing your house, and then charging you with the cost of demolition. It is important to file these cases in federal court. Otherwise, the cozy relationship that the county government has with your local county judges will ensure that your building will be demolished or your rights will be violated before the appeals courts can step in and give a remedy. I will give you an example in case law from California because that is what I am most familiar with. I have helped a few people with this kind of a problem, and I know a lot of solutions to these kinds of issues, and I know how to approach these problems so that you are successful with stopping code enforcement from taking your money or your property without just compensation. Most of the time, they are violating your rights or the United States Constitution, and they are using their position of government authority to make money from the distress they are creating for you. There is one requirement that you need to understand at the very beginning, that you will need to learn and understand the law, and you will need to be able to stand up for your rights in court and learn to speak intelligently in court. So you will have to learn something about the law. If you are afraid of speaking in court or unwilling to learn something about the law, then I suggest that you find an attorney. First of all, you will need to prepare a federal lawsuit, and with the proper captioning. Here is an example of what it needs to look like on page 1. You will need to title the court case as follows: District Court of the United States. Do not title the court as U.S. District Court, since the U.S. District Court is a territorial court, which is acting under the authority of Article 1 of the Constitution. And an Article 1 court, which operates under the authority of the United States Congress, is not the kind of court you want to be in. You want to be in an Article 3 court. The 50 several states have all been admitted into the Union as Union states. So they are not territories of the United States. The state governments are not territories of the United States government. It appears that the U.S. government has been operating under a bankruptcy since 1933, and they have been treating the state governments as instrumentalities of the United States government and basically co-bankrupt debtors under the bankruptcy. And this is why they call the federal district courts United States District Courts. If you read Mukini versus United States, 58 SCT 543, and Balzac versus Puerto Rico, 258 U.S. 298, dated in 1922, both of these early cases state that the District Court of the United States is an Article 3 court, and the U.S. District Court is a territorial court. The federal court clerk will attempt your legal document, will accept your legal documents either way. So they'll take your case either way, whether you file it as a U.S. District Court or you file it where you title the document where the court is a District Court of the United States. As I say, I prefer to title it as a District Court of the United States in order to make sure that I'm invoking Article 3 of the Constitution. So that's why I prefer to go into an Article 3 court, and this is how I caption it. Now, if you want an authority on the whole concept that the United States government is in bankruptcy, you want to look on March 17th of 1993 in the Congressional Record. There you're going to find Congressman Traficant makes reference to this fact, and it is very clear. He states that the United States government is in Chapter 11 bankruptcy. So there's our evidence. Now, the next thing to do is to name the defendants. You must name the defendants as follows. If a county government agency, such as code enforcement for the county, is violating your rights, then you need to identify the county as the defendant, as well as any identifiable person who works for code enforcement or the code enforcement department as your defendant. So anyone involved in violating your rights that you can clearly identify, somebody who has sent you letters or spoken to you in person, that kind of thing. So you will want to state that that individual person is being sued in their official and their private capacity. You can also just name them in their private capacity. If you name them in their official capacity, you need to come up with the evidence that they are acting under an official policy directive, and that the department they work for has established official government policy to do what they are doing, which you are alleging to be an unlawful act, which violates the United States Constitution. I will give you one example for the purpose of discussion so that you can understand in general terms how to write the lawsuit. One of the things you will need to do before filing a lawsuit is to mail the government a tort claim. You'll want to mail the local government a tort claim. Now, the requirements in every state are different, so you will need to research the legal requirements for your state before preparing the tort claim. In California, there are some very specific requirements for preparing and serving the tort claim. You will need to mail the tort claim to the County Board of Supervisors at their address. And I would suggest sending it certified or registered mail so you can prove that it got delivered. If a city government agency violated your rights, then you will need to mail the tort claim to the city manager or the city treasurer. Now, you will need to include certain things as follows: your name and mailing address, the names of the people in the government agency who violated your rights, the date, place, or other circumstance of the occurrence or transaction which gave rise to the claim asserted, a general description of the indebtedness, obligation, injury, damage, or loss incurred so far as it may be known at the time of presentation of the claim, the dollar amount of the claim. If it is less than $10,000, should also be included. I usually state the dollar amount of the claim regardless of whether or not it is more or less than $10,000. If they have not done anything to cause you injury or damages yet, but you think they will, then you can state that you believe that they intend to cause financial loss or damages, and then you need to state the dollar amount of the claim if they demolish your building or damage something of value. In the case where they have not yet destroyed property or injured you in any way, then you will need to title the document as a petition for declaratory and injunctive relief, and then make reference to Title 42, United States Code, Section 1983, on page 1 of the lawsuit. You will need to state the following on page 1 below the reference to Title 42, United States Code, Section 1983. Demand for a trial by jury. Now, the citation of Title 42, United States Code, Section 1983, is a reference to the section of federal law that makes it unlawful for people to violate your rights secured by the Constitution and laws of the United States of America. The actual wording is as follows. Section 1983, civil action for deprivation of rights. Every person who, under any statute, ordinance, regulation, custom, or usage of any state or territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured by an action at law, suit in equity, or other proper proceeding for redress. Now, it goes on to cite some sections regarding judges, which we don't really need to address here. It's very difficult to sue a judge, and that's not within the scope of what we're going to be talking about. So, we'll skip over that portion. Please note the term action at law is included here in Section 1983. This action at law is a lawsuit filed under common law. It's widely understood that that's what the word action at law means. So this means that under common law, you cannot be deprived of your rights to a trial by jury. Equity law is a species of law whereby the right to a trial by jury can be optional. But under the rules of the common law, you have a right to a trial by jury. This means that a judge cannot dismiss your lawsuit arbitrarily, otherwise he is taking on the role of a jury. Federal judges tend to overlook these things unless you point them out in your lawsuit or in other paperwork or in the oral argument before the judge. This particular law was enacted by Congress in the late 1960s or early 1970s and was initially designed to provide the recently freed black slaves and their offspring a remedy for the violation of their rights under the Constitution. Originally, the U.S. Constitution was written to exclude black slaves from citizenship. So the 14th Amendment was written to address this problem and to make recently freed black slaves a citizen. They are referred to as citizens of the United States or U.S. citizens. The intent of Congress at the time that this was enacted was to give freed slaves rights and freedoms and to protect them from serious violation of their rights in the southern states where the freed slaves were treated as second-class citizens. The intention was not to make everyone else U.S. citizens. Everyone else was classified as a state citizen. If we look at the decision by the California Supreme Court, which discusses this, it is Valkenburg versus Brown, 8 Cal 43, which states as follows. The history and aim of the 14th Amendment is well known, and the purpose had in view in its adoption well understood. That purpose was to confer the status of citizenship upon a numerous class of persons domiciled within the limits of the United States, who could not be brought within the operation of the naturalization laws because native born, or whose birth, though native, had at the same time left them without the status of citizenship. These persons were not white persons, but were, in the main, persons of African descent, who had been held in slavery in this country, or if having themselves never been held in slavery, were the native-born descendants of slaves. The U.S. Supreme Court spoke about the 14th Amendment in Yickwo v. Hopkins, 118 U.S. 356, 1886, in which they stated that the 14th Amendment gave everyone, even foreigners, the protection of their rights under the Constitution. The U.S. Supreme Court stated as follows in Yickwo v. Hopkins. The 14th Amendment to the Constitution is not confined to the protection of citizens. It says, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. These provisions are universal in their application to all persons within the territorial jurisdiction, without regard to any differences of race or color or of nationality, and the equal protection of the laws is a pledge of the protection of equal laws. It is accordingly enacted by Section 1977 of the revised statutes that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white persons, and shall be subject to like punishment, pains, penalties, taxes, licenses, and sanctions of every kind, and to no other. The questions we have to consider and decide in these cases, therefore, are to be treated as solving the rights of every citizen of the United States, equally with those of the strangers and aliens who now invoke the jurisdiction of the court. So although the government likes to classify everybody as a U.S. citizen, you can see that the U.S. citizen is only a freed slave or their offspring. As a result of the Yickwo versus Hopkins case, it is clear that anyone within the territorial jurisdiction of a state has rights that can be protected by the 14th Amendment, and they are not thereby defined as U.S. citizens because they are invoking civil rights laws or the 14th Amendment. Some people will try to assert that everyone is a U.S. citizen, and the act of registering to vote or getting a driver's license or paying taxes is an admission of adopting a status as a U.S. citizen. This is clearly not true. The citizenship status is not changed by the voter registration and similar activities. If we were waiving rights, there would have to be a full disclosure of this. Otherwise, this would be fraud. There is a United States Supreme Court case that governs this. It is Brady versus United States, 397 U.S. 742 at 748 and 749. Somewhere in your lawsuit, you need to state that the defendants either knew or should have known that they had no lawful rights or government powers to do what they did when they violated your rights. I will now supply one of the most common examples that is used by code enforcement to deprive people of their rights. You receive a notice in the mail that states roughly as follows: we are going to demolish your building because the government agency involved, code enforcement, has determined that your building does not comply with the current building codes. and this means that this is a nuisance, which must be abated immediately. Otherwise, the building will be demolished. Then, if you are in California, you may discover that the California Court of Appeal, First Appellate District, in Lepo versus City of Petaluma, 20 Cal App, 3rd, 711, that's dated 1971. By the way, 3D is shorthand for third. And the case is stated as follows. While we have not found authority in California that states where the burden of proof lies, other jurisdictions have held that the municipality has the burden of proof of the nuisance and the necessity for its immediate abatement. See Solly versus City of Toledo, Supra, 218 Northeast 2nd at 466. Crossman versus City of Galveston, 112 Texas, 303, 247 Southwest, 810 at 815. Lawton versus Steele, 152 U.S. 133 at 135. 14 SCT, 499, 38 LED, 385. LED is shorthand for Lawyer's Edition of the Supreme Court reports. We feel that the reasoning of these cases should be applied here. Such conclusion is consistent with the rule requiring the state to have the burden of proving the necessity for taking of private property for public use in condemnation proceedings. The court went on to say, we conclude that in emergency situations, the city may act summarily to abate a nuisance, but in such case, the city must be prepared to establish by a preponderance of the evidence that an emergency actually existed. This was the burden imposed by the appellants by the trial court, upon the appellants by the trial court. As a result of the Lepo case, the appeals court in California stated that only an emergency that places the public in danger will justify the forced demolition of a building by the government. It also is apparent that the courts in California have stated that a nuisance abatement must be determined by a court and not by an administrative tribunal. See Camille versus Buena Vista Cinemas, 57 Cal App 3rd, 497, 1976, which stated the following. The first and foremost requirement is a judicial determination prior to abatement of the obscene character of the films under prevailing law. Patently, the city council could not, by ordinance, adopt its own definition of obscenity, and even the most formal administrative proceeding to determine the issue of obscenity under prevailing law could not suffice to be a substitute for a judicial determination. And now in this case, the court was discussing a case involving a pornographic movie, adult movie theater, in which the city was trying to classify which types of movies would be classified as prohibited. But the overriding ruling here is that it has to be determined by a court and not by a city council or a county board of supervisors. Now, we're really more interested in property rights and this kind of thing rather than pornographic movies in this particular video. But the case amplifies the fact that the judges have to be involved. There has to be a judicial process, not an administrative process. And the city council is a legislative body, not a group of judges. They cannot function in a judicial capacity. In some California counties, the County Board of Supervisors adopts the role of a court, which violates the California Constitution. which guarantees that there has to be a separation of powers between the legislature, the legislative, judicial, and executive functions of government. This can be found at Article 3, Section 3 of the California Constitution. This doctrine is stated in a case that originated in San Diego in a case called Strumsky versus San Diego Employees Retirement Association, 11 Cal 3rd, 28. That's dated 1974. The California Supreme Court stated that the California Constitution prevents the executive branch or administrative departments of government from functioning as a court, which is a judicial function of government. The court stated as follows: because judicial powers may no longer be exercised by local agencies, the factual findings of those agencies are entitled to no greater deference than those of other agencies lacking judicial powers under the Constitution. So they make it very clear that administrative agencies cannot function in a judicial capacity. And of course, this is true of the Board of Supervisors. They're really a legislative body, not an administrative body, but they cannot cross the line into functioning as a judicial body because they're not judges. We have a separate branch of government called the judiciary that deals with judicial functions. And that's the overriding principle here that applies with the Strumsky versus San Diego Employees Retirement Association. Federal judges are bound by state appeals court decisions, and they all know this. They're all aware of this. Now, let's talk about the U.S. Constitution and how the local county government can be found to be violating your rights under the U.S. Constitution. First of all, let's be clear about one thing. The state and county governments are bound by the United States Constitution. In California, for example, the California Constitution states at Article 3, Section 1, that the U.S. Constitution is the supreme law of the land. All government employees take oaths of office whereby they agree not to violate the U.S. Constitution. In many cases, they do not know what the U.S. Constitution says or how the U.S. Supreme Court has ruled on many important subjects. If you know your rights and you can enforce them, this knowledge can shift the power back into your corner. The U.S. Constitution states at Article 1, Section 10, that no state shall pass any ex post facto laws, and it also states that no state shall pass any bill of attainder. The term ex post facto in this context means that no state can pass a law that retroactively imposes a requirement that governs a particular aspect of your life. They can't turn the clock back and change what happened before. So, for example, the state cannot retroactively impose a law that requires you to bring your house that was built, without building codes or before building codes were ever enacted, to change the house to incorporate new building codes. The U.S. Constitution at Article 1, Section 10 also makes it very clear that it's unlawful to pass a law that is a bill of attainder. A bill of attainder is a law that imposes a fine or some sort of a penalty by legislative fiat without a judicial process such as a trial by jury. As a result, we can see that many acts by code enforcement agencies can be seen as unconstitutional. Another way to challenge the actions of code enforcement based upon constitutional grounds is when they have declared their intention of seizing or destroying property without a warrant that meets the requirements under the Fourth Amendment. The Fourth Amendment states as follows: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Please note that the requirement is stated that the government must have a warrant that is supported by oath or affirmation. This means that they have to produce a sworn statement by someone who has witnessed a criminal act or a violation of someone's rights or some other violation of the law that justifies the use of the warrant or the court order. Sworn statements must be sworn in front of someone who is qualified to administer an oath. This is frequently not done by code enforcement, although it is sometimes necessary to check the records to see if there is a warrant supported by oath or affirmation. We can examine a case in Illinois called Soldal versus Cook County, a U.S. Supreme Court case. The citation is 506 U.S. 56, dated 1992, where the government seized a mobile home without an official court process or court order that was supported by oath or affirmation. The U.S. Supreme Court found this to be unconstitutional. The U.S. Supreme Court has spoken several times about the requirement that originates in the Fourth Amendment that compels the government and the courts to provide a warrant that is supported by oath or affirmation. In Kalina versus Fletcher, 522 U.S. 118, in the late 1990s, the U.S. Supreme Court stated that the government must have a criminal complaint that is supported by oath or affirmation in order to prosecute crime. A similar case went before the U.S. Supreme Court in 1806. The case was Ex parte Burford, 7 U.S. 448. Another way to challenge the validity of code enforcement's action is to challenge the constitutionality of the statute they are relying on for their claims, that they have the power to force you to change your property or upgrade to current building codes. The U.S. Supreme Court has also stated that an arbitrary and capricious policy violates the Equal Protection Clause of the 14th Amendment. See Baker versus Carr, 369 U.S. 186. That's dated 1962. And that, once again, that's Baker versus Carr, 369 U.S. 186. In People versus Mason, the California Court of Appeals stated that there has to be an actual injury when it comes to abatement of a nuisance. The court stated as follows: the infirmity of the present injunction is that it ignores the question of actual injury and is framed to cover even the slightest musical or related sound which can be heard beyond the boundaries of defendant's property, regardless of whether such noise causes any injury to the nearby residents. Then they cite Thompson versus Kraft Cheese from 1930, 210 Cal 171. Now, they make one note here that sometimes attorneys try to tell you, convince you, that old cases don't have any force and effect. That's not true. If they haven't been overturned, they're still the considered precedent, and they're still considered the controlling law in your state or your area. So the well-established California Supreme Court rulings or California Court of Appeals rulings, until they're overturned, are in effect, whether they're from the early 1800s or when they are. In order for actions taken by the defendants to be restrained by the court, it must be shown that such actions are clearly arbitrary and unreasonable, having no substantial relation to the public health, safety, morals, or general welfare. And that's Cusack versus City of Chicago, another U.S. Supreme Court case, 242 U.S. 526. So what they're saying is in order to restrain defendants, government defendants, uh, the courts have to be shown that that action that's being taken by the government is arbitrary and unreasonable, having no substantial relation to the public health, safety, or morals. Okay. Now, once again, if the building that you're living in isn't going to run out into the street and bite somebody in the leg, then they can't say that somebody could be potentially injured from your building. If even if it's not up to code or in compliance with the current building codes. This similar case is cited by the Ninth Circuit Court of Appeals, N Pacifica LLC versus City of Pacifica, 526 F 3rd 478 at 484. That's the Ninth Circuit Court of Appeals in 2008. The Ninth Circuit covers Montana, Washington, Oregon, California, Arizona, Nevada, and Hawaii, Guam, and American Samoa. So there are quite a few states. Montana is included, and I believe Alaska as well. Frequently, the local laws, such as county ordinances or city ordinances, are poorly written, so that the ordinance never really identifies who is required to comply with the ordinance or who it applies to. Frequently, there are loopholes in the law, or these laws are written specifically for building contractors and not the homeowners or the general public. Now, it is frequently discovered that when we look more deeply into the law, we can find references that make it obvious that there is no actual requirement for homeowners to do what they are asked to do by code enforcement, because the codes do not apply to them. But you have to dig a little deeper into the law than most people do, and most attorneys included into that category. People have used the Equal Protection Clause of the 14th Amendment to raise the questions related to who is required to do what the law states and whether or not the law really applies to you, especially where it's vaguely worded so that it's void for vagueness. Now, that's a legal concept that's widely recognized in the law. If it's void for vagueness, you cannot impose a requirement on people if it's too vaguely worded. There is a case, a U.S. Supreme Court case, I believe it's Connolly versus General Construction, although I'd have to look that up to double check it. But there is a case on that about vaguely worded laws. It is then necessary to briefly state what the government defendants have done to violate your rights and why it is a violation of your rights. If you can identify either people in your community, other people in your community who have had their rights violated in the same way that you've had your rights violated, these examples will demonstrate a pattern of behavior that tells us that this is a custom and policy of the government that they have adopted, which you can clearly state in your lawsuit meets the requirements under federal law for establishing a pattern of behavior and a custom and policy. Then you should discuss and identify the defendants and why they are defendants. What they've done what they've done to violate your rights is what you really want to be very specific about. Next, you will state the causes of action, which is the focal point in a general statement of the specific wrongdoing in the claim for damages that gives you a rationale to sue the defendant for damages. You should refer to the lawsuit as a claim for damages and not a complaint. The use of the word claim invokes common law. One of the causes of action has to be deprivation of rights under color of authority. violation of Title 42, Section 1983, and that's Title 42 United States Code, Section 1983. Then you state why the defendants violated the statute. The specifics could be violation of the Due Process Clause of the 14th Amendment, for example, because they never brought the case in front of a court for litigation, as required under Camille versus Buena Vista, as discussed earlier. In this case, you should state that they violated both your procedural and substantive due process rights because they did not hold a hearing, nor did they bring it before a jury. Violations of procedural due process means they did not hold a hearing or meet some other procedural requirement like a search warrant. Violations of substantive due process rights means that they violated your due process rights because they have failed to give access to a legal remedy or blocked your due process rights by preventing you from any redress of grievances, which is again, by the way, guaranteed by the First Amendment to the United States Constitution, the right to redress of grievances. Under Cummings versus Missouri, 71 U.S. 277, dated in 1867, the U.S. Supreme Court made it crystal clear that the state courts are required by the U.S. Constitution to conduct a trial by jury under the rules of the common law. And they don't want you to know about that, but that's a very important case. Cummings versus Missouri. Another cause of action is when you are asking for declaratory or injunctive relief, or both of these. The court can issue an order ordering the defendants to refrain from demolishing your house unless they determine, through engineers and other experts, that your building is presenting a danger to the public. This is called an exigent circumstance or an emergency. In most cases, your house is not going to jump out and bite someone in the leg. However, if bricks are falling on people's heads or on a nearby sidewalk, then the government must step in and supply a remedy to protect the public. Generally, the public is not placed in any danger by a single-family dwelling. At the beginning of each cause of action, you will want to state that all of the preceding paragraphs are incorporated by reference, as if fully stated herein. When you come to the end of your lawsuit, you will want to specifically state what remedy you are seeking under the heading Relief Requested. If you are asking for punitive damages in California, you must insert the fact that the defendants have engaged in oppression, fraud, and malice. At the end, you should have a place to write the date and then sign your name. After that, you will insert a paragraph that is a verification paragraph. And the exact wording is as follows. Verification. I have read the petition for declaratory and injunctive relief and the claim for deprivation of rights under color of authority, and know the contents thereof to be true, and the same is true of my own knowledge, except to the matters which are therein stated on my information and belief. And as to those matters, I believe them to be true. The foregoing is true, correct, complete, and not misleading. Then you fill in the date, have a place to fill in the date, and then you sign your name a second time. So you will be signing your name twice. You will want to download the civil cover sheet from the federal court's website and download a summons. Here's how to fill out the civil cover sheet that you insert, where you insert your name and address at the top. List yourself as the plaintiff and the county government as the defendant. Then, if there are other defendants, then place a comma after the county and write the words "et al." Next, you will fill in the next part by stating that the basis of jurisdiction is that the matter involves a federal question, and that in part, in the part about the citizenship of principal parties, if you're not stating that there's a diversity of citizenship, you don't even have to fill that out. And you're not going to be stating that there's diversity of citizenship. So that's not even something you have to fill in. Now, under the section titled Nature of Suit, you will check off section 440 under Other Civil Rights. And then you will state below the origin that the case is in original proceeding. So you have to check off the part that says original proceeding. Put a check mark right there. Under cause of action, where it states for the U.S. civil statute you are relying on for your lawsuit, you will want to enter the words Title 42, comma, U.S. Code, comma, Section 1983. And you will want to enter Title 28, U.S. Code, Section 2201 and 2202. Where the form asks for a brief description of the cause, you could simply state Due Process Clause, 14th Amendment, or 4th Amendment, or whatever the part of the U.S. Constitution that you are basing your lawsuit on. You could say Article 1, Section 10 of the Constitution, if you want. There are usually generally specific sections that are prohibited, where states are prohibited from engaging in certain activities. So that's pretty much how you would want to proceed there. Now, then you write in the dollar amount of the claim that you are making against the defendants. Then date and sign your name as the attorney of record. So you are acting as your own attorney. With the summons, the upper left side will identify the name of the plaintiff, and then below this you will list the defendants. Below, you will see there's a section for the name and address of the defendant. Fill in the full legal name of the defendant and their address. Then you will look for the paragraph below that starts with the words, within 21 days after service. Now, there's some additional wording in that paragraph, and just below that paragraph, there's a space provided for the name and address of the attorney. You write your name and mailing address there. When you go to the court clerk's office, then they will sign the summons and they will place a court seal on the summons and give it back to you. They will also rubber stamp your lawsuit and give you back a copy. You'll want to show up with at least 2 or 3 copies of the lawsuit, one original and 2 or 3 copies. Now, at that point, you're ready. By the way, when you're done with all the legal documents, you're ready to either mail this or bring it to the court in person. You can do it either way. If you mail it in, you're going to have to enclose a self-addressed prepaid envelope with enough postage for them to return at least 1 copy of the lawsuit along with the summonses and a copy of the civil cover sheet. And they will rubber stamp the summons, or they'll put an embossing seal on the summons, and they'll sign their name. And they'll rubber stamp the first page of your lawsuit. And you need to enclose a $400 filing fee. It does cost $400 to file a lawsuit in federal court. That's the current filing fee as of today. Now, at this point, we thank you. And if anybody's interested in reversing cancer or looking at alternative cancer cures, herbal and natural remedies that don't involve side effects, that is available on our website. And the website will show up on the screen in front of you if you're interested. Just copy that down. And we also have a book on natural remedies for reversing diabetes. And thank you.